Prosecutor, along with Phoenix Dominguez, Rob Spada, and Lisa Lindsay.
Your Honor, Jim Hardman, Jim Thomas, and William White, defendant, Mr. Kilpatrick.
Okay. First of all, I think that we all are aware here just on the circumstances of this matter, of his historical significance and all of the factors that surround it that's been played out in the media for the last few months, and particularly the development of yesterday. None of that is lost on this court. And but I do wish to say, of course, that has nothing really to do with this, because we have to deal with this as any other case and make those decisions that any judge has to make when he's faced with such circumstances as this. Let me say from the first off that because very often when judges do and make decisions, questions are raised about where what factors might be involved, with that. So I want to make it very, very clear from the very beginning. And I say this because yesterday, after this matter came to me, and before I go there, let me set the boundaries here. This is before me as the appeal from a lower court, and I think that, and I will hear from the lawyers more on that in a minute. I think that also are some boundaries that are set procedurally, by that factor. Anyway, yesterday after this matter came to me, and I said I would look at it, today, I asked that certain things be provided to me, and transcripts, and so forth. And because the defense was bringing this motion, I thought the burden was on him. I just got that about maybe 5 to 9 or 9 o'clock, this morning, although I had already looked at the essence of what Judge Giles had said and the reasons for his opinion before that. But I would have liked to have had this, sooner than I got it, since I asked for it yesterday right around about 1 o'clock. But that's doesn't hinder my decision-making process here, because I was aware of the gist of what Judge Giles had said. Also yesterday I received several phone calls, one from a female attorney who was a past member of the Detroit City Council, who's on the mayor's team, and also from an attorney who is a former justice of the Michigan Supreme Court, who also identified as being part of the legal defense fundraising, for the mayor. I did not talk with those persons. I thought it was inappropriate, for them to call me. In my 20-some years on the bench, I think I have never gotten a direct call or personal call from either of those persons. So I assumed they were not calling to wish me a happy day or happy Friday morning. So I didn't take the call. I think it's easier for me to say I didn't talk to someone than to talk to someone and try to explain what was said or what was done in that process. I have no alliance, allegiance, or agenda involved in this matter, and whatever would be done be by force of law and legal procedure. Now, with that in mind, I first of all want to establish from the prosecution and hear from the defense, or from both sides, what legally are the boundaries of this court in terms of making this kind of a decision. We are aware of MCR 6.106. I have my thoughts about it from my research yesterday, but I want to hear from the lawyers, please. Go ahead.
Thank you, Your Honor. Yes, MCR 6.106, subsection H, little 2, little a, defines the differences between an emergency application for review of a bond prior to an arraignment on information, and little b is after arraignment on information. My understanding of the law, or the reading of the court rule, was pretty clear that in order for a court to review a release decision by a lower court before an arraignment on the information is held, there has to be a substantial reason for doing so before a court modifies the decision or even reopens a custody hearing. A substantial reason. Paragraph 1 under H, under MCR 6.106H, says that on this modification there must be an abuse of discretion standard. It's different after an arraignment on the information. If this court were the court of jurisdiction and an arraignment was conducted and you were the court that had jurisdiction on this case, you could review the bond de novo and do what you felt was appropriate. But for purposes of this hearing, because the defendant has not been arraigned on the information, the court first has to find there's a substantial reason for even having a hearing or even addressing the issue of the pretrial release. And if the court does do that, then it looks to the standard of abuse of discretion.
So, in other words, and I hear from the defense here, your reading of that is that MCR 6.106 subparagraph H1 regarding appeals to an abuse of discretion with no de novo evidence or hearing.
That's correct.
In other words, that I'm confined to whatever the record is made by Judge Giles.
Yes, Your Honor.
All right. Let me hear from the defense.
There is one issue that I wish I had some law to give you because we looked and couldn't find it, and that is this. The proceedings yesterday in the district court occurred in this order. The preliminary hearing was waived by both parties. At that moment, my understanding and my suggestion would be that the case was then transferred to the circuit court, that at that moment, at that point in time, the district court lost jurisdiction, and therefore you can hear this de novo. Now, I understand in looking at some Michigan law that there is some reasoning, and this is against us, but this is some reasoning that an oral order from the court may differ from a written order. In other words, until the district judge actually signs the transfer, that he may maintain jurisdiction of that. I just could not find any law one way or the other, but I would suggest to the court that one of our grounds is that you would be hearing this de novo because of the lack of jurisdiction of the district court at the time that he heard the bond issue after the preliminary was waived. Number two, Your Honor, to make it real quick, I do not disagree with the prosecution in that if I am incorrect, sir, about the jurisdiction issue, then you would be reviewing this on an abuse of discretion, which we are also prepared to go forward with. Thank you.
Okay, very well. Any other response, Mr. Moran?
Just on that, Your Honor, my recollection of the hearing, I haven't had a chance to read the transcript, which I got about 5 minutes ago, was that the intention was made clear prior to the court accepting the waiver of the preliminary examination that the bond issue was going to be revisited. And the court, Judge Giles, before he took the waiver, he said, I'll take the waiver first and then deal with the bond issues, and that was without objection from the defense.
You're saying that someone from the the prosecution team mentioned that, I think I did read that part, before there was a formal waiver of the preliminary exam, that issue was brought up.
That's my recollection.
But it wasn't ruled on, it just was brought up, and then procedurally he took the waiver and then decided to review the bond circumstance.
That's correct.
Right, okay. Now, what is your response to what the defense counsel is saying about the somewhat hypothetical procedure, I would say, that once the preliminary exam was waived, that the jurisdiction then left Judge Giles and came to this court, even though it has not been blind drawn or formally assigned?
I think my position is that they waived that yesterday when it was made clear in the beginning, before the waiver was accepted by the court, that other issues would be resolved. They could have said, no, Judge, we have to resolve these beforehand. Okay. They acquiesced in allowing the waiver to go forward and then proceeding with the bond hearing. So
that would put you back at your original position then of saying that I am limited to the 6.106 provision H1, which basically says that I have to find an abuse of discretion in order to do anything with what Judge Giles did, and that is not a de novo hearing where I can take other evidence or other factors and weigh those in, that I am essentially limited to determine whether Judge Giles made an error, essentially and what he did, or whether he abused that discretion in making that decision. That's your position, right?
That is correct.
Okay. I'll give the defense the final word on this, and then we'll hear some more arguments on the procedural.
Yeah, okay. One of the procedural points is that the bind-over wasn't official until the defendant signed the bind-over form, which was done after the conclusion of the bond hearing. So after he waived it on the record, the defendant didn't sign the bind-over waiving his right to the written court order until after the bond